Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
I want to say good morning and welcome to everyone. This is the call of the docket for the Court of Criminal Appeals, February 2026. Good morning to all of you who are here, and welcome, and to those who are joining us on live streaming on our YouTube platform. Welcome to you as well. Just a reminder that these arguments are being live streamed and stored on the AOC website, and anytime you want to go back and review these arguments, they're there for that. It's a great tool that we've had since the advent of COVID. I wanted to welcome you and then also introduce the panel that I have the privilege of sitting with this morning. I'm sitting with a couple of the sharpest legal minds in the state of Tennessee, and I feel privileged to be with y'all. To my left, and your right, is Judge Tom Greenholtz. Judge Greenholtz has been a member of the court since 2022 and was a former trial judge in the 11th Judicial District from Hamilton County. To my right is Judge John Campbell. Judge Campbell has likewise been a member of the court since 2022 and is a former trial judge from Shelby County in the 22nd Judicial District from the western section. And my name is Tim Easter. I've been a member of the court since 2014, and I'm from Williamson County. You have the privilege of having what I call a grand panel, which means you have representatives from each of the three grand divisions from the east, the middle, and the west to hear oral arguments today and tomorrow. As everyone is familiar with our procedure here, you have 20 minutes per side for oral arguments. If you are the appellant and you wish to retain some time for rebuttal, please let us know when you approach the podium at the beginning of your arguments, and we'll reserve that time for you. We do use the light system here, so you have a green light, of course, is go, yellow light, 1 minute, and red means you're done. And we appreciate if you would follow those lights. Madam Clerk, are there any preliminary matters before we get started this morning?
No, Your Honor.
Okay, thank you. Let's call the first case.
State of Tennessee versus Martinez, Obrien, Carter.
Good morning.
Good morning.
Mr. Chapman?
Yes.
You may approach. Mr. Chapman, do you wish to reserve any rebuttal time?
Not particularly.
Okay. And you can use your full 20 minutes on the front end.
Yes, sir. Mighty fine morning once again to the three of you. Of course, I represent Mr. Martinez, Carter, and if there was a theory on appeal, we would argue that the cumulative effect of these errors created a trial where the defendant was branded a prisoner, and the accuser, rather, was shielded from confrontation. With regard to issue one, the extraneous prejudicial information, i.e. the custody status, the standard, we argue, Tennessee Rules of Criminal Procedure 24C2B, wherein a juror may be challenged for cause if they have a state of mind that prevents impartiality. And we argue that exposure to custody status creates this bias. Now, one of the cases that we argue, I must admit, is a civil case. But when you got lemons, you make lemonade. And in this connection, it establishes the general principle that exposing a jury to a party's custody status is inherently prejudicial and could well be persuasive with a view to a new trial hearing. Of course, the state will and has relied on State v. Adams regarding the burden to show bias, and Estelle v. Williams regarding very brief and limited glimpses or brief or limited exposure.
Let me stop you for a second, because looking at the record, and you have this incident where the deputy approaches, I guess, toward the bench and tells the lawyer, your client is changing clothes in this room. And my question to you is, I know that there was an individual call that I think a girlfriend of the defendant or some associate of the defendant that was sitting in the front and said that she could hear what they were saying. But I didn't see any proof to indicate that the jury was in a position to hear what was being said at the bench.
Well, she was, Tammy English was sitting in the gallery, further away from where the Veneran were. She was just she's back off, and surely, if she could hear it from the gallery further off in distance, surely the Veneran could have heard it as they were sitting closer. That's our supposition.
Well, I understand that's a supposition, but you also have a situation where what was said, unless you infer that the jury would think the person was in custody, the fact that, he's changing his clothes, does that automatically mean that he's in custody? Or it could have been where he was inappropriate, or, in Shelby County, we have sometimes lawyers bringing clothes for their clients to change into because they just don't have a good wardrobe, or they wear something inappropriate. So isn't that, you have to infer from that?
There are certain instances that have to be inferred, but we argue in this instance, our client changing clothes, and then there were other places where they mentioned that the bus was running late, and it wouldn't take, jurors are smart, it wouldn't take a smart jury to be able to put two and two together.
Well, Mr. Chapman, let me follow up, if I could, please, on Judge Campbell's question. Mm-hmm. So one of the lemons that the state is trying to hand you is State versus Adams. Mm-hmm. Adams requires, in these exposure cases, requires the defendant to produce admissible evidence showing that jurors were exposed to extraneous prejudicial information. And I think that language is straight out of Adams, must produce admissible evidence. I don't understand that we have admissible evidence here. I think what it looks like is we may have a thought that it occurred, we may have speculation that it occurred, we may have conjecture that it occurred, but we don't have a juror's affidavit saying that a juror heard the statement. We don't have a juror testifying saying that the juror heard the statement. I can't remember what rule of evidence is. Maybe it's 605 or 607 maybe. We don't have any of that kind of proof. How do we get around Adams?
Admit it. We admit that, but what we do have...
Well, isn't that fatal then to your claim?
Well, I don't think so. Because yes, what we have is an authority figure stating aloud about changing clothes. And we argued that we need not interrogate the jurors to provide the risk that existed. The records show that the statement was made and audible in open court.
Well, but before an extraneous information claim can be brought, I think you would have to show that, one, the juror was actually exposed to it, right? And that typically the only way you could prove that, I would believe, would be having a juror saying, yes, I heard it. You can't ask the juror about how it affected the deliberations or the thought processes, of course, but you at least have to have that. Otherwise, we may just have speculation. And I wonder if under Adams, speculation is not admissible proof, as the Supreme Court seems to require the standard to be.
Well, if the court would, for the purpose of this exercise, suspend disbelief and follow us along the lines of proximity of where this statement was made, where these participants were situated in the courtroom. And if a person in the gallery further off can hear a statement, cannot the veneering closer to have heard it? And
And again, to Judge Campbell's point, I believe it was his question, there was no indication that he was changing out of some type of prison clothing into courtroom clothing, was there?
and that's right.
So
but-
there would be some speculation involved there.
It could be by itself, but you couple that with the statement that the bus is running late. And you got the bus running late, and you got the guy is now later in time here, changing clothes. And so, suspending disbelief. If
So this bus running late statement was made by the judge, correct?
and well, by the same Mr. Cryer.
By the
Court
court officer,
And
so not by the judge.
not by the judge, by the court officer. The bus running late earlier in time, and then later in time, your client is here now changing in the jury room. And the logic is, or the logic can be, inferred. Now,
But I think that's just to close the loop on that, though, Mr. Chapman, I think that's what
Yes.
you're asking us to do, right? You're asking us to close the loop. You're asking us to presume a fact rather than the fact to be proved. Is that correct?
well,
You're asking us to close the loop and make that inference rather than relying on evidence in the record.
well, I want you to close the loop, but close it amongst yourselves after this argument is made. We're hoping that the dominoes fall, or the tumbler, if you're safe cracking, all fall just right.
Fair enough, Mr. Chapman, fair enough.
Now, with regard, we're talking about the totality of the situation of this prison bus question. Now, the facts are that the prosecutor asked the witness, Paul Bledsoe, about conversations that he had with my client, Mr. Martinez, while on this bus, on the TDOC transport bus. Now, the state distinguishes State v. Nash to say that Nash requires manifest necessity for a mistrial, and that brief references are just merely harmless. And we argue that Nash looks at the totality of the circumstances, and here the manifest necessity arises from the cumulative effect. First officer, then later prosecutor. One slip very well may be harmless, but when coupled together, it creates a ticklish pattern that a curative instruction cannot fix. Now, talking about limitation of impeachment, that is to say the CI, the rule being Rule of Evidence 607, where credibility of a witness may be attacked by any party, and the state would argue that 609, impeachment by evidence of conviction of crime, limits the inquiry to the fact of the conviction and not to the details. And they cite State versus Morgan. Now, we argue that this Summer Anderson's death, the young lady that died while she was in jail of an overdose, here we sought to ask the CI, Alexander, about the overdose death of the inmate, Summer Anderson, and the CI's own overdoses in jail.
Let me ask you this, what was your purpose, or the purpose for asking this question? What was the purpose for bringing this out?
Well,
How was this impeachment?
not to attack her. Let me first say, under Rule 609, we were attacking her on the 608B, specific incidents of conduct regarding truthfulness and bias.
Okay,
And so
now,
the fact-
But here's where I'm having a problem analyzing this. What proof is there that she had anything to do with the death of this person in jail, other than she had been a drug dealer in the past? Do you have any credible evidence that could have been offered to the court to show that she was involved in this overdose death?
Had we been allowed to further our line of question, the fact that she may have been involved in the death in custody and was not charged thereof would have created, we would have argued, a massive motive for her to lie to the state. And that bias.
But what is the proof that she actually was involved in that? You can argue, oh, well, this person died, but what, you have to have more than just a theory. You have to have some factual basis, don't you, in order to establish this bias? Don't you have to show that somehow she actually was involved?
Well, what we would have said is that we would have argued that her ongoing criminal conduct, doing an investigation, creates a reason to question her.
But you're talking about propensity evidence then, right?
That's right. And we're talking about the whole reason that they relied on this CI was her sterling credibility as it relates to him, my client, not only being a weed man, but selling heroin as well. And all of this lies on her credibility. And if we're able to show that she's not even credible about what she was doing in jail while ongoing drug dealing was going on, and that occasioned the death of someone that she may have had some culpability for. And because she had skin in the game to load up on that lie so that it didn't blow back on her with not only not being believed on her testimony in this case, but her being culpable later for a murder that occurred. And also she had probation that was pending at the time. And if she didn't play it straight and crawfished on her deal with the state in the background, she wouldn't have had her probation reinstated. And so she had more than reason, bias type reason. Now the state argues, state versus IPOC. They say that identifying victims of past offenses is not permissible as underlying fact, to which we argue IPOC dealt with the identity of a victim in a past theft. Here we're talking about an ongoing criminal conduct, as I said, using, distributing drugs in jail that occurred while she's cooperating or holding herself out as a rehabilitated witness. This goes to her competence. Can she remember events if she's overdosing? And her motive? Is she testifying to avoid homicide charges? And so...
Do we have, Mr. Chapman, do we have, going back to maybe Judge Campbell's questions, do we have any evidence that she was subject to homicide charges?
We didn't get that far.
So once again, it may be a situation where you're asking us to take a couple of things on faith, and I wonder if we can. You would have had the opportunity, I believe, to have proven that fact up maybe at the hearing on the motion for a new trial, where you had the opportunity to call her, to question her, to put into the record the facts that you believe you would have elicited at trial. But she wasn't called on the motion for a new trial, and so it seems like you're asking us again to take a couple of things on faith here. I'm a little bothered by that. Could you clarify that, please?
Well,
could you give me some comfort?
If the court sets aside the homicide blowback possibility and just deals with the deal that she had to have cut to testify when she still had these pending probation violations, that alone is enough for her to walk the line and to testify in a way that doesn't squirrel her deal with the state.
But then at that point, though, you're back under 609 because we're dealing with a conviction, introduction of contraband into a penal institution. And if we're back under 609, then we're not allowed then to talk about the facts of underlying the conviction.
But
Right.
if we go back to 608, we're talking about a bias again, and then we're talking about her already saying on record that she has been certainly known to lie if she's under pressure. And so she's already on record saying that she'll lie if it came down to it.
Okay, so, but how does that go to her giving drugs to somebody in the jail and them dying from it?
Well,
There's no evidence in the record that that happened.
and that's why we predicated this line of discussion on setting that aside for now and just dealing with the skin that she had in the game, to have to continue to lie so as not to go against what she told the state that she would do, testify truthfully, even though she's told you she's done it in the past. That's bias, 608. She had reasons, she was biased, whether it was with regard to the murder or if it was just simply regard to toting the line as it related to her probation. And I wish I had 2 minutes and 11 worth more stuff to talk about, but I find myself at the end of credulity.
Thank you, Mr. Chapman.
Thank you. Thank you.
Thank you.
Ms. Chapman, you can have a seat over here at council table if
Thank
you'd like. That's reserved for you. General?
Good morning, Your Honors, and may it please the Court. Tommy Archibald for the State of Tennessee. This Court should affirm the convictions below. Martinez Carter sold drugs to a confidential informant. The whole crime was on tape, and the evidence against him at trial was overwhelming, but he nonetheless wants this Court to give him another bite at the apple in the form of a new trial. It should. As the State sees it, there are really 3 issues in this case. The issues relating to potential disclosure of Mr. Carter's pretrial custody status, as we discussed, the evidentiary issue relating to the questioning of Summer Anderson, and then a sufficiency of the evidence challenge we didn't really talk about initially, but I'll say a word or two about that because we did brief it. So we're going to take all those issues in turn. It's important to clarify at the beginning, and this didn't come up, that we're on a highly deferential standard of review here. We have an abuse of discretion standard with respect to the disclosure of his custody status and the evidentiary determinations, and then the any rational juror standard for sufficiency if we even get to the substance of that issue to begin with. So we'll start with the custody status. So it's crucial to emphasize here with respect to both of these issues that Tennessee courts have never held that brief and incidental disclosures of a defendant's pretrial custody status necessitate a mistrial. There's binding Tennessee Supreme Court precedent on that question out of the Grosclose case, and then this court has said so repeatedly and essentially without exception. So even sort of taking every inferential leap that my friend on the other side would like this court to take, at best it still leads to a legal dead end with respect to the brief and incidental disclosures of the custody status.
Right, as I understand your friend's argument, though, and it may have shifted a little bit here at oral argument, it isn't a one-off. He says that it's a cumulative effect. So we have, at the beginning of the trial, we have, taking the argument in a light most favorable to the defendant, a clear revelation that the defendant is having to change out of prison clothes, and then later being reminded, because his friend is testifying during trial as to a conversation that happened on a prison bus. How was the witness dressed at trial? Was his friend the witness? Was that witness dressed in prison garb? Was that witness dressed in street clothes? What does the record reveal about that?
Your Honor, I'm not sure. I don't think there's...
And it would matter, right? I mean, so if that witness is dressed in prison garb, and he's saying, I had a conversation with my buddy on the way back from the penitentiary, and this is what he told me, coupled with, hey, I'm trying to hide this early on because I'm changing into clothes, that kind of matters, doesn't it? So isn't there more than just a legal dead end? There's a cumulative issue here?
So perhaps, Your Honor, I want to first start with the cumulative error question. I think we have like 5 responses to that ultimate question. The first one is that the factual circumstances of the first one are highly disputed. As this court sort of drew out in its questioning my friend on the other side, the notion that the first instance here actually did disclose Mr. Carter's custody status is highly speculative.
Don't mistake me. Excuse me. I'm sorry. Don't mean to interrupt. Don't mistake the question. I'm not presupposing the merits of the argument. I think where you started off with, though, was that he's at a legal dead end because he can't show any effect or impact. And I'm suggesting what his argument was a little bit nuanced. And that argument was we can take the effects of each and accumulate those effects. So what's the response to that?
Sure, Your Honor. I think at best, sort of two isolated reminders to the jury of the defendant's pretrial custody status doesn't rise to the level of the constitutional standard and Estelle of a constant reminder throughout.
It wouldn't be isolated, would it, if the witness on the stand is testifying in prison garb? That's constant. That's not an isolated reminder. So does the record reveal how that witness was dressed?
So, Your Honor, I don't think it does, and to the extent that it doesn't, it's the burden of my friend on the other side in order to make that showing. He certainly hasn't briefed that issue, and like I said, I don't think that issue is in the record. So in as much as there's doubt as to that question, it's going to ultimately redound to the benefit of the state. Additionally,
Let's back up for a second, though, because you couple not just what he was wearing, but the state's the one that opened this inquiry up about this conversation on the bus, and highlights it, I guess is the best way to put it, in front of the jury. This guy's in custody. He's in custody with this other person, and they were talking on the bus. Doesn't that kind of highlight in a much more vivid way than just these other passing references that may or may not infer that the person was in custody? This is pretty direct, isn't it? Enough for the judge to issue a curative instruction.
Yes, absolutely, Your Honor, and we have always thought that the Bledsoe claim is a stronger claim. However, this court has still held in similar cases that those sorts of incidental disclosures by the prosecutor, improper lines of questioning, don't ultimately rise to the level of necessitating a mistrial. I would direct this court to the Corso case that addressed a very, very similar fact pattern with respect to a prosecutor asking a witness, I believe the witness's wife, how many times he had visited him in jail pending trial, and there, even without a limiting instruction, this court still nonetheless held, relying on the scores of cases distinguishing the Estelle case from the Supreme Court, that the defendant was not entitled to a mistrial on appeal. So with that, I will turn to the evidentiary question, assuming the court doesn't have any more questions with respect to custody status. So here, recall the defense counsel objects to the fact that the court did not allow him to cross-examine the CI about a speculative theory, namely whether her conviction for introducing drugs into a prison led to the death of Summer Anderson, a fellow inmate. That objection is baseless, and the trial court cited 3 independent grounds for excluding that evidence, and each of them are sufficient to affirm, particularly under an abuse of discretion. So I'll take all 3 of those in turn. The first one...
Well, how about this before we get there? The state's brief cites 402 and 403 as the governing rules, but as I understood the framing of the argument, it's either 609 or 608, depending upon whether there are convictions. And of course, 609 and 608 each have their own independent balancing test. Why is the state's brief focusing on 402 and 403? So,
yes, Your Honor, and I would refer to you, we have record cites in the brief to the motion, or to the hearing rather, regarding the motion for a new trial, where the trial judge does, in fact, cite 402 and 403 as alternative bases.
Okay, but what is the actual argument here? Is it a 609 argument with a conviction? Is it a 608 argument otherwise? Because what I understand... Judge Campbell had asked this to your friend, what was the purpose the evidence was being offered for? I understood the answer to be it was being offered for impeachment. And so that places us firmly into 609 or 608, depending upon whether a conviction is involved. Doesn't put us into 404, doesn't put us into 403. What's the analysis here under 608 or 609? Is there help me with that, please?
So, yes, Your Honor. So we think that the trial judge cited the wrong rule here and ultimately was relying on 609. There were ultimately
Okay, so that's an abuse of discretion possibility, right? Because with an abuse of discretion, if you rely upon the wrong rule of law, that's by definition an abuse of discretion.
So I don't think so, respectfully, Your Honor. If you look at the Cannon Mills case from the Tennessee Supreme Court, again, we cite that. That case stands for the proposition that if a trial judge cites the correct principle of law, which he did, but ascribes it to the wrong sort of rule in the rule book.
Did the trial court apply the correct balancing? Because 403 balancing is different than 608 or 609 balancing.
Your Honor, there's nothing in the record to suggest that he didn't apply the ordinary 403 substantially more prejudicial than probative analysis.
And is that balancing test different than the balancing test contained internally in 608 and 609?
I don't think so, Your Honor. I'm not sure.
Okay.
So
If it is, if the balancing tests are different, does that amount to an abuse of discretion then?
I don't think so, Your Honor, because I think each of these are individually independent bases for excluding the evidence. So ultimately, irrelevant evidence is not admissible ever. 403 is always a permissible basis on the back end of any rule of evidence analysis.
Sure. And I'll let it go after this, but if it's being offered for impeachment, by definition, it's relevant. And so then we're only talking about whether the purported impeachment attack then is permitted by 608 or 609. I'm trying to figure out what rule we're actually going under. Is it a 608 issue? Is it a 609 issue? I think we're agreed that it's an impeachment issue, so it has to be one of those two rules. Which one is it?
So, Your Honor, I think it's excludable under both. Ultimately, the trial judge relied on the 609 principle from State versus Morgan that says that questioners are not allowed to go into the underlying facts of the conviction. That is a well-worn, well-established principle of Tennessee law. And here, I do think my friend on the other side was seeking to go into the underlying facts.
Okay, the facts of the conviction, though, he was trying to bring up a homicide. There's not a homicide conviction. From what I can tell from the record, and you'll correct me, but from what I can tell, the only conviction involved is introduction of a controlled substance into a penal institution. He's talking about a homicide. So if there's not a conviction for that, are we back into 608 where you can ask about other acts?
So yes, Your Honor, except I think this was, in fact, related to the conviction for introducing drugs into a penal institution. As I understand my friend on the other side's argument, it was that the CI had introduced the drugs into the prison. Ultimately...
And he's talking about something further. He's talking about further distribution, though, and the further distribution having an impact on someone else.
Yes, Your Honor, but I think that is inextricably linked with the act of introducing drugs into the penal institution, because ultimately they ended up, or as he tells it, they ended up with Summer Anderson, who then ultimately took them in.
There is a conviction.
There is
a conviction for the offense of introduction.
Yeah, yes, Your Honor,
Okay.
and that was introduced into the record. Additionally, on 608, my friend on the other side didn't brief it, but again, because the trial judge did bring it up, and then Judge Greenholz, you asked about it, there are two independent bases additionally under 608 that pose a problem here. So in as much as the court is willing to entertain that theory at all, the two problems are, number one, 608 requires the evidence to go to the witness's credibility. Here, my friend on the other side has not articulated any reason why the unforeseen downstream consequences of him introducing of her introducing drugs into a penal institution ultimately bears on the witness's credibility at trial. Additionally, 608B requires a hearing outside the presence of the jury to make these sorts of assessments. That hearing did not occur, and so the evidence is also would have been inadmissible on that basis absent that hearing. Finally, I'd like to talk about sufficiency a little bit. Two things important of note. My friend on the other side briefs this as a weight of the evidence claim. We, sort of giving him the benefit of the doubt, interpreted it as a sufficiency of the evidence claim. We have clear evidence in the record that the trial judge fulfilled his 13th juror requirement, which is the only permissible basis for a weight of the evidence claim. Additionally, we think that Mr. Carter has a waiver problem here for insufficient briefing. He did not cite the underlying principles of law here, as is required under the Tennessee Rules of Appellate Procedure, rules of this court, and this court's precedent. But nonetheless, we think the evidence of his guilt is overwhelming, even setting aside anything from the CI. He briefs and then stood up here and said that the state's case turns entirely on the credibility of the CI, setting aside the fact that at this stage in the game, we don't reassess the credibility of witnesses. The state had plenty of evidence beyond the CI to support his conviction. I would point you to Exhibits 2 and 6 in the trial record. Both of those are videos of the entire crime taking place that was presented to the jury. We had multiple state witnesses from law enforcement officers that were witnesses to the sale. We have forensic evidence. Simply put, the evidence against Mr. Carter is overwhelming, and so no matter what you want to do with respect to the CI's testimony, there's plenty of evidence to support the conviction. If there are no further questions, the state will rest on its briefs. Thank you.
Thank you, sir.
Thank you.
Thank you both for your arguments, good briefs. Thank you.